Welcome, everyone. I'm Denny Brennan. I'm the Executive Director and the Chief Executive Officer of the Massachusetts Health Data Consortium. And I want to welcome you to today's MHDC Executive Forum. Before I get into the specifics of today's forum and introduce our co-chairs and esteemed guests, I'd like to go through some working matters for today's discussion. First, today's session will be an hour, but we will have a 30-minute optional add-on when the meeting is concluded for those who are able to stay and continue conversations that we have started or that folks want to continue during the course of the meeting. We welcome your participation. We call this a forum because in the old days when we sat around a table, we would exchange ideas, we would talk with each other, we would freely ask our speakers and others what their perspectives were, and we want to encourage that today. So please use the Q&A, raise your hand, or ask a question. We encourage that kind of interaction. Thirdly, this meeting is being recorded and it will be available on our website in a couple of days, and you'll be able to access, or your colleagues will be able to access the meeting after that time. Just before the end of today's session, there will be a survey popped up from Zoom. We ask that you complete the survey. It's very brief, but it does help us understand how well we're doing and what might we be better doing in the future. So now let me introduce our co-chairs. David Carusio will be joining us in about 30 minutes. Dave is the Chief Technology Officer at Point32. Bill, why don't you introduce yourself?
Good morning, everyone. I am Bill Young. I'm the Chief Information Officer at Berkshire Health Systems, and it's been exciting to be part of this interoperability journey with Denny and the Mass Health Data Consortium team. Today, I'll let Denny introduce Adam, but an exciting, good opportunity to discuss, security as it relates to sharing data. So Adam, welcome. But I'm going to put a plug in for the next couple too. I know I'm a little bit out of order, but we've got John Halamka and Stephen Konya on November 9th. The uses of AI, artificial intelligence, such a topic right now. And closing out the year, we started with Alexandra Muggy and Mickey, and we're able to close out the year with both of them. Watch out, a new date. I encourage you to join us on December 12th. They'll both be in the same virtual room together and have a great opportunity. With that, I'll turn it back over to Denny and Adam. Thank you. Welcome. Excited to have this conversation.
Thank you, Bill. I appreciate that. And Adam, I'm not going to introduce you. I'm going to ask that you introduce yourself, because we have talked before, but you are doing new and interesting things. And before we get into the topics of today's discussion, I'd like to, as well as the rest of our audience, know a little bit more about you. Could you spend a few moments telling us about your work and your areas of focus and why you're here today?
Thanks, Denny. Thanks for having me. Happy to introduce myself. So my name is Adam Green, and I'm an attorney at Davis, Wright, Tremaine in our DC office. And my practice focuses on health information, privacy, security, breach response. And over the past few years, the newest addition has been information blocking has become a big part of it. And I've been with DWT for about 12 years now. Before that, I was at HHS, first in their Office of General Counsel doing HIPAA work there, and then in the Office for Civil Rights as the, at the time, newly created position of Senior Health Information Technology and Privacy Advisor. So working on new technologies and how HIPAA applies them, and working very closely with ONC at the time.
Thank you very much. We appreciate it. And we've always looked either directly in meetings like this or following you online for some of the perspectives you bring to privacy and security especially. But let me share a little bit with our audience about how our forum is going to work. We have 3 questions today that we're going to ask Adam. And after each question, we're going to turn to you as an audience and ask if you have any questions or comments. No pressure. We do want to be sure, though, that we're getting the perspectives of all in the room, if you will. So why don't we go to the next slide and let's talk a little bit about HIPAA. HIPAA is almost 30 years old, and there are aspects of the security rule that may, and we'd like to ask you if you believe, need to be updated to account for the many changes to technology, processes, and culture in the intervening years.
So 30 years in information security, that's probably like 200 years if you're kind of doing kind of a dog year comparison sort of thing. And for that age, I think, it's barely got any gray hairs. I think it's actually doing pretty well, all things considered. I remember when I was at HHS, I attended a meeting, and afterwards, someone came up to me and said, I want to tell you guys, I really appreciate the security rule. This person kind of represented physician practices and said, really appreciate the fact that the security rule is very reasonable and flexible and doesn't assume that everyone is a large national healthcare provider or something along those lines. And it really is scalable. And I really appreciate that. Not that long afterwards, I remember doing a presentation, and afterwards someone from the audience came up to me and said, I got to tell you, I really can't stand the security rule. Just tell me what I need to do so I can do it. So there's always been this double-edged sword with respect to the flexibility of the security rule. Some people loving it, some people hating it. But overall, I side with how important that flexibility is. I think that rulemaking is a very slow, cumbersome, painful process. So unfortunately, rulemaking could never catch up with technological innovation, though, to the extent that we'd want to in the area of information security. So I think having this high level and flexible approach has served us very well over the years. And moving towards interoperability a little bit, I remember attending a meeting once where it was kind of a information security like leading body, and one of the people there said, what I really don't like about the HIPAA security rule is we put in place robust information security based on the level of sensitivity and the risk level of the data. And it just doesn't make sense to me, from my information security background, that we should be expected to share that data with someone else who doesn't have those same level of controls in place. I mean, the controls should be commensurate with the information and its risk. And I think there's a lot of validity to that view, but from a practical standpoint, the entire world would come to a grinding halt if every small provider was expected to have the same level of controls as your much bigger, more well-resourced healthcare providers. So I know in the world of interoperability, some people don't like the differences in security when you go from one place to another, but I think it's unfortunately a practical reality. That being said, one thing that I'd love to see changed, and I think there is a bit of a movement in this direction. We saw a few years ago legislation that provided for HHS to take into account if someone has adopted recognized security framework and kind of implemented that over the past 12 months. I think more could be done on the security rule to incorporate frameworks in that respect. So, maybe in the regulation itself, give greater credit, give, essentially, you are in compliance with the security rule if you have complied with one of these frameworks, because that way you still have the flexibility for those who need it. But for those who want greater level of assurance and detail, there is something that they can look at and know that they're in compliance with the security rule by following that framework. And those frameworks can adjust a lot quicker than regulation, generally speaking.
Well, that makes a lot of sense. It's always struck me that the attestation model of security compliance is necessary, but in some respects, it's insufficient. There, we can't tell people there's no such thing as, you're HIPAA certified. That doesn't exist, and people sometimes use that phrase, and there's really no such thing. But there is this gap between sort of I've attested to being a secure steward of my data, and I'm certified. But that ground that you're striking, that middle ground of, if you can go that much further to comply with one of these frameworks, and I assume you're referring to like NIST or HITRUST or one of the bodies out there that has a set of tools and associated procedures that one can go through and formally, quote unquote, comply using that framework, you would get a little bit further down the road to some measure of assurance. Are you seeing more and more organizations adopting that? Or are you seeing that in your practice, that organizations are saying we would feel better if we went that much further and adopted one of these frameworks as a model of compliance?
I mean, I think those who can often do, but many can't. So I don't think, small providers are oftentimes not in a position that they have the resources to try to comply with NIST 800-53 or HITRUST necessarily. Maybe the cybersecurity framework, but on the most part, their focus is, if I can at least try to check off the roughly 50 or so boxes under the security rule, that would be good. Versus, I think more sophisticated and more well-resourced entities who are also oftentimes facing bigger threats, I think they realize the security rule is not a detailed framework, and they really need to look to something like a NIST or a HITRUST to set a much more robust framework for them.
Do you find yourself in this regard talking to clients about what their technology providers can offer, or how they should work more closely with their information technology on the provider side, an EHR and EMR provider, for example? It's not always the technology. There are a lot of human factors and operational factors, but providers really rely on their electronic health record technology. And while they can sort of secure around the periphery of that technology, within that technology, there are complexities that vendors might be able to help them with. Do you see any progress in that direction, with vendors being more closely, working more closely with their customers to tighten the security of their applications?
I think part of this comes to my role as kind of outside counsel. So, I don't tend to get involved as much with kind of the day-to-day security, but I find myself on kind of the opposite side of your question, which is sometimes making sure people are not relying too much. I think a lot of times when they come to me, it might be that they think of it as kind of, oh, our EHR provider takes care of these things, so
Handles
we
all
should
of that,
be good. Right? And it's like, well, your EHR provider can't do a risk analysis for you. And so even, when you look at the security rule and having administrative, physical, and technical safeguards, I like to work with clients to understand, okay, your vendor may be able to take care of most of the physical safeguards. You may be relying, if you're relying on a cloud provider, you're relying on their data centers to have the appropriate physical safeguards, but you still have to, have physical safeguards around your workstation that access the cloud. So don't forget about that. On the technical safeguards, this is where things get really confusing, because you'll have the software vendors saying, oh yeah, our software is HIPAA compliant, which there's no such thing as HIPAA compliant software. Their software may have technical measures that help support your, as an organization, HIPAA compliance. And so understanding, okay, they have some of those technical safeguards that if you must appropriately configure and employ. But then a lot of times it's reminding them that the administrative safeguards, while they have to, they have to do their own risk analysis, they have to, as a business associate, they may have to comply themselves, but you still need, there's no true plug and play software with respect to security rule compliance. You still need to, no matter how good their security is, include them in your risk analysis, have the appropriate monitoring in place, that sort of thing.
Great. Janice Karen, you have a question of Adam.
Yes. Hi, I wanted to ask, do you think that any of how much do other components of the HIPAA rule affect security, and do people consider how they interact with each other? For instance, the requirement to use specific transactions, or can you talk a little bit about how HIPAA as a whole affects security and not just the security rule?
Sure. Yeah, I haven't seen the transaction standards come into play too much with respect to the security rule. You may have, for example, when two entities are doing appropriate HIPAA covered transactions with each other, you may have a trading partner agreement that sets forth certain technical specifications to, where I see the bigger intersections would be privacy and breach. I mean, breach obviously, is a flip side of the security rule. If you do everything right, you still may have a breach. I mean, there's 0-day exploits that can't be avoided, but certainly, breach is the stick with respect to making sure that you do a good job on the security rule. I think the bigger challenge is sometimes the privacy rule and patient privacy rights and security. So take encryption and communications with the patients. I remember when I was at HHS, there wasn't much guidance out yet on the idea of, can I communicate with a patient through unencrypted email? And from the security officers, the security people would often say, no, of course not. You should not be sending PHI unencrypted through email ever. But the privacy rule includes a right of the patient to an alternative form of communication. And so, we end up having this kind of dance where under the security rule, encryption in transit is addressable, which means where it's reasonable or appropriate, you must implement it. But there might be circumstances where you determine that it's not reasonable or appropriate to encrypt. Maybe you decide sending an appointment reminder from a primary care practice that it's not reasonable and appropriate to encrypt that transmission. So the security rule kind of sets a baseline, but then the privacy rule allows the patient to overrule your decision. So maybe on the one hand, you said, okay, we can, we need to send treatment communications via encrypted means. So maybe it's a patient portal or something like that. If the patient says, I want you to send it to me via an unencrypted email, if it's reasonable for you to do so, if you can readily do so, then you don't get to say, nope, your security is too important to us. We're not willing to do that. You have to actually comply with the patient's request if you're a healthcare provider. And the flip side, if you've determined that it's reasonable to send PHI unencrypted, and the patient comes in and says, nope, I don't want to receive appointment reminders via unencrypted text message or unencrypted email, then you have to accommodate that request. And so that's where I've oftentimes seen the most tension. The fact that essentially when the privacy rule with respect to at least patient rights and the security rule bump up against each other, the privacy rule wins.
We have a question from David Delano who asks, are you seeing that there are more frequent or more aggressive security risks in today's environment that your clients are coming to you and expressing a special concern about? And how prepared do you see the industry in addressing these newer threats if they are indeed preeminent or predominant in the environment today?
So unquestionably, the threats are getting bigger and more challenging. I mean, our organizations are more complex. It's always been a struggle because, you have to build the castle with all of the walls, and all it takes is finding, one weak spot for the hacker, the outside entity to get in. And the castle's getting more complex each day, bigger, more challenging to defend each day. And the weapons on the other side, now we have essentially hacker technology as a service, where people without even a great level of sophistication can obtain tools to be able to become proficient hackers. And now add AI to the mix, and the idea of hackers being able to use AI to potentially advance threats. So the challenge from, say, 2003, when the security rule was published, take a look at the definition of security incident. It's become laughable. The definition of security incident includes attempted and successful unauthorized access, use, disclosure, modification, deletion. And so we have this remnant from 2003, where a business associate agreement should require a business associate to report every security incident, which arguably means every attempted security incident. Everyone now contracts around that, because no one on either side of that wants to be disclosing every single attempt, because today, every moment there's new attempts being made, and it's just that's par for the course. So it's really become that much more challenging. And that's where I think, going back to the question on the screen, one of the things that the security rule has done very well is not try to address very specific threats, the threats of 2003, but rather have a flexible framework where OCR, the Office for Civil Rights, has focused on risk analysis as their primary foundation. And your risk analysis should be, your risk analysis from 2 years ago is not going to cut it today, because we do have new risks every year that need to be updated. And so I think the focus is in the right spot in that respect, that, it all comes down to a risk analysis that is constantly being updated to reflect the new environment and new challenges we have.
I'm sorry, I muted myself for a moment there. Why don't we move to our next question? Thank you, Adam. All right, with so much interoperability, I'm moving my window here so I can read the screen. With so much interoperability and new technologies in healthcare, like telehealth, remote patient monitoring, third-party apps, consumer health devices, artificial intelligence, digital assistants, connected hospital beds, and more, and there's a lot more, how do you make sure the proper controls are in place to limit security breaches as much as possible?
So this actually gets back to the point that I was just mentioning. I think the focus by OCR and risk analysis makes a lot of sense. It's constantly pushing yourself to really evaluate the new risks that are occurring, with new consumer health devices, with AI, with greater interoperability and more connections between your organization and others. It really is every time. It starts with the data map. Where is electronic PHI coming in? Where's it being stored? Where's it going out? How's it getting disposed of? And each of these new technologies potentially adds to that data map. And then really thinking critically about what are the risks here with respect to these new technologies. Are our current controls sufficient to address these new technologies, these new risks, these new areas where ePHI may be popping up, that sort of thing? And so, I think that's foundational. You don't need to use an external party to conduct your risk analysis, but I do think it's fairly key that the people architecting these solutions are not the same ones necessarily evaluating the risk, because it's almost impossible to kind of review your own work to a sufficiently critical level in that respect. So whether it's that you've got IT and security sufficiently separated that security can take a pretty critical and objective view of what IT is doing, or whether you're bringing in an outside party, really making sure that as you have these new technologies, you're implementing them into your data map and looking critically at the new risks that they bring. A risk analysis should not be strictly a once a year, once every 2 years exercise. I mean, it's, you can't have new technologies come in and say, well, we'll address that when we have our vendor come next March. That just doesn't work. You need to, you should have, ideally an annual risk analysis, but it should be organic, and you should be augmenting it and reevaluating it all the time based on new technologies and security incidents and things of that nature.
Well, I feel pity, I feel compassion for the organizations that this has become the portfolio of technologies, and it's expanding, and they come from vendors who are not necessarily subject, or at least attentive to, some of the regulations and the requirements that go into this. And as a CIO or a chief information security officer, this becomes an extraordinarily complex challenge. Do you see in your practice organizations who have adopted especially stringent or especially innovative approaches to dealing with this proliferation of new internet connected technologies? It's really the internet that is, fundamentally at the heart of this, and the fact that everything is connected. Do you see organizations taking more draconian measures, or organizations working only with vendors or do you advise organizations to work only with vendors who have policies of a particular type? How do I, as a client, come to you and say, help me figure this out, help me make sure that I'm doing, not technically, and I understand you're not a technical, you're not an information security officer's technology ally, but you are someone who can help them understand from a regulatory and a risk exposure, how do I begin to manage my contracts with these vendors? What are some of the things that I need to be especially mindful of as I start looking at this proliferation of connected technologies?
Well, especially where I get involved, the answer is not always pretty. The reality is, oftentimes when I get involved in a contract and business associate agreement discussion and things of that nature, I mean, I do see, a greater maturity than when I came to practice about 12 years ago. I do see a greater level of, assessing, the vendor security, what they have in place, via, whether it's a security questionnaire or a security exhibit. 12 years ago, business associate agreement says, vendor, you must comply with the security rule. And people weren't necessarily looking for much more than that. Now you may have I'm seeing more and more where you may have a robust security exhibit. But that being said, I think the reality is I still don't see that many clients that have the resources to really dig deep into their vendor security the way they'd like to. There are tools out there. We see vendors that their role is to assess other vendors, that to assess the security. Maybe there's a few that are doing that, but on the most part, frankly, when I'm involved, it's oftentimes, okay, fighting over indemnification and limits on liability, and almost always it's a matter of, well, the vendor says we've got great security, but we don't necessarily have the means to check that, and we have, they want a limit on liability that we end up fighting over, and at the end of the day, the risk, most vendors that are sophisticated are not going to agree to unlimited liability, unfortunately. And so at the end of the day, it's great to risk assess your vendors, like how much PHI is going over to them. Is it, on their systems, or do they just have access? Is it social security numbers and, particularly sensitive? And that can inform the discussion of what level of diligence we should be doing on their security so that we can prioritize our diligence, and what level of indemnification we should be looking for on the contractual side. But at the end of the day, most of the risk oftentimes still falls on the covered entities, that they don't have the resources to do the diligence. And this is just, one of the risks they face is that our vendors are going to be the problem no matter what we do.
Thank you. Janice, Karen, you have a question?
Yeah, as a follow-up to what you were just talking about, you were just saying that most companies don't have the resources to really delve into security and privacy practices of their existing vendors and partners. But there's also a clamoring in some cases to have the ability to delve into the security practices of, for instance, third-party app developers. Can you talk a little bit about the balance between is that just a pie in the sky? We'd like to be able to do that, but we don't have the resources. Is that a legitimate ask? And can you talk about how that kind of fits into the landscape?
Yeah, 12 years ago when I started in private practice, I remember, I can do a presentation on security and security rule compliance, and the security officer would say, yeah, everything you've said is accurate, but I don't have the resources to do that. The only exception that I'd find would be the one who, that organization suffered a really big breach. They fired their security officer. They brought in a new security officer, and that security officer was really well resourced. Back, 12 years ago, those are the only ones who seemed to have the resources that they felt like they needed. I've seen improvements since then. So, security is something that is keeping CEOs up at night now, and I think there is greater resources going, but it goes back to the battle and the unfair lines. There's so many resources needed to defend one's own castle against all the potential vulnerabilities out there, that it's still, there's improvements with respect to the ability to review vendors and look at third-party app developers and what they're doing. So I don't want to say there's no improvement at all. There is, but it's still, I think, such a long way. And I think it's a relative minority of sophisticated healthcare providers that have the resources to be doing that, whereas the vast majority can't even keep their own house in order necessarily.
Yeah, I guess.
Go ahead,
sorry.
Janice.
Part of
No,
the
go ahead.
I guess part of that discussion, part of why I honed in on that discussion, is that currently the regulations don't allow them to vet third-party apps for security. They can
when you
make
say third-party
recommendations.
app, there's, if I'm a hospital, there's could be a third-party app that I hire to do something, or you're talking about consumer
Right.
apps.
Gotcha. So the regulations in some cases for consumer third-party apps don't allow
consumer third-party apps.
people.
Okay.
I apologize, but you're absolutely right. It is a wider discussion as well.
Yeah, that, and we may get into this a little bit more later, but I think, the reality is the government has made a choice to, put the risk on the consumer with respect to third-party apps. So essentially, it would be information blocking to even if you had the resources to look at a third-party app and say it's got terrible information security, you still, if the best you can do without it being information blocking would be to inform the consumer of your concerns. But if they say, yeah, but it's really helpful, it's really convenient to me, you have to share the information with that third-party app. So really the best you can do, unless we're talking about like the connection between you and that third-party app is insecure, that would be a separate story. But if your connection is secure, but you think they've got terrible security, even if you have the resources to go and look at every consumer app, the best you could do is then educate the consumer and leave it to their choice. And unfortunately, I don't think many healthcare providers have the resources to evaluate consumer apps when they can't even necessarily evaluate their own service provider apps, and then, provide the level of education that would be most helpful to consumers. Does that better answer your question, Janice?
Yeah, no, I just was struck by the dichotomy of having so many companies saying we don't want to do this unless we can vet these apps, and you're saying that companies don't even have the resources to vet the apps that are falling under HIPAA.
Yeah, and when the information blocking rule was first proposed, I mean, that was the big, people saying you can't push all this data to be available to apps outside of HIPAA, where it's completely the Wild West. And, it's a very valid concern. But one, it's not completely the Wild West. The FTC does regulate those apps. And now we have the Washington My Health, My Data Act, and Nevada and Connecticut have followed in the footsteps. We're seeing states starting to pay more and more attention to the regulation of the consumer apps. Now they're focused on privacy, but to the extent that those apps don't have good security, that itself would be a privacy issue. So, we may see greater enforcement at the state and at the FTC level, rather than an expectation that the hospitals who are sharing with those apps are expected to evaluate their the security practices of those apps.
Well, the FTC discussion is a good segue to our next question. So if we can go to question number 3. The FTC data breach rule considers unauthorized disclosure of data equivalent to an active data breach, and all existing enforcement actions have been for unauthorized disclosures to advertisers. This type of data misuse is becoming more common. How can we reduce its frequency and limit its impact when it does occur?
So I think
What
I
are your
probably
thoughts
have
there?
an old enough audience that they'll remember, like when I was growing up, you would have that, it's 5 o'clock, do you know where your child is? Or it's 10 o'clock, do you know where your child is? So, it's 2023, do you know what your communications team is doing? Do you know what your marketing team is doing? I think that is the most important starting point. When I remember one of the first class actions in this area back in 2019 or so. And I had entities that were coming to me, they saw that class action, they said, oh, we're doing the exact same thing. So we need to be worried. But I remember speaking at a conference, the Healthcare Compliance Association's annual conference, and I co-moderate a privacy officer roundtable. And based on that class action, I raised the question to the audience, hundreds of privacy officers, okay, is the following information, like the fact that a particular IP address, went to your patient portal, is that protected health information under HIPAA? And the vast majority said no. It was, maybe like 30% said yes, 70% said no. So, not that many years ago, you had privacy officers didn't necessarily think that this information was PHI. You had maybe a few sophisticated healthcare providers recognizing what their marketing departments were doing, but most had no idea what we're doing. And then, fast forward a few years, we had OCR guidance come out in December of last year, if I remember correctly. And that really brought this to the forefront for a lot of people. And what I would find was, even when the privacy office and legal office went to their communications, their marketing department, and asked what information is leaving our website, sometimes they wouldn't know because they outsourced it to a marketing company that just said, oh yeah, we're going to make sure, we're going to show you the return on investment of your different campaigns and things like that. And they had no idea what was actually leaving their website because they had outsourced that. So I think one of the most important things is first finding out what's going on with your website. Within the past year, I've seen a cottage industry develop with respect to consultants who will look at your website and identify what's going out the door. So if you have the internal resources, great. If not, there's now a lot of people vying for your business to tell you what information is leaving your website. I think getting a handle on that is the first most important thing. And then, of course, only once you get that handle can you then, do the proper evaluation and say, okay, we think information leaving our general website is fine. The OCR guidance said that's okay if it's not associated with the person's search for a doctor or a particular sensitive condition or things like that. But here, and here, these disclosures from our website, absolutely not. I mean, everyone should have the ability to go onto their website, do a search for, like abortion would be a classic example, and then understand exactly what third parties are receiving that search term. And if you're not able to do that, a plaintiff's attorney or a regulator potentially will do it for you. And so much better to find out now and do that and fix any issues than finding out the hard way.
Well, this is, one of the themes that comes through this is we work with what we have as far as the regulations, as far as the guidance, as far as what we can accommodate as organizations, because we can't afford, in most cases, to do everything. And even then, the definition of everything changes from year to year. It becomes more and more expansive. As you talk to clients, and as we look at this intersection between the FTC and the OCR when it comes to the enforcement of privacy and security, but especially security of these data, do you see any particular, what's the best way for me to ask this question? Are there approaches to addressing these challenges that you see some organizations taking that are novel, or that are that you see as being sort of beacons of hope, where organizations have started coming out with the kinds of practices for dealing with an emerging consumer economy, for dealing with the fact that their websites may have information on them and may be providing information that they're unaware of? Are you seeing organizations that have developed their own set of capabilities that are more expansive to deal with these problems, and have as a result become incrementally more secure, not totally secure? We know that's not possible, but incrementally more secure, and are staying ahead of this without, driving themselves into bankruptcy. What are some of the novel approaches, or the leading approaches, I should say, that you're seeing among organizations in addressing this increasing complexity?
I mean, for me, it all comes down to a good risk-based approach. For me, the best clients are the ones that are not just, I think foundationally you should have a good controls framework. But for me, the best, the clients who are doing the best are the ones that see, having a good controls framework as a starting point and not an end point, and that are really focusing on, okay, we have the framework, we have auditing in place to make sure we're following that framework, but now we really need to be focused on risk and looking at, have good mechanisms to identify the risks around the corner. I mean, when that first class action in 2019 happened, with respect to website disclosures, I had maybe 2 clients that were reaching out to me on the issue, and I tried to publicize the issue where I could, but I had a few clients, but a very small minority that were kind of, had the good mechanisms to be able to say, oh yeah, this is a new risk area, we need to get on top of this, rather than, clients that it took years for, and it took kind of OCR hitting them over the head with, guidance, and then the FTC and OCR sending out joint letters, who are only now realizing. So, it's a good example of, really looking, following the headlines across, legal risks related to cyber. Certainly, you hear a new news story about plugging your phone into a USB port at an airport. what are the risks in doing that? Evaluating, okay, is that a real risk that we need to be worried about and put some resources towards? Or yeah, it's a nice theoretical risk. It's it's fun at the RSA conference, but that's not one that I think is a top priority for us, compared to this headline about AI being used to develop new exploits. That's something we need to focus a lot more on. So I think it's really having the good foundation of a good controls framework, but really then focusing on identifying the new risks and having the resources to then address them, which is easy for me to say sitting here, a lot harder for everyone to do in practice.
But you're right. I mean, ultimately, in the absence of a suitable framework and a method of work in terms of dealing with these challenges, it's overwhelming. I mean, if you don't have a way to structurally, rationally assess risk and to sort of work from right to left, what is, if something were exposed, what's the chance of that happening and how likely is it to cause me problems?
Yeah.
And then working back from that, it seems, that's really the only way we can deal with this increasing level of complexity. It's
right.
There are no answers. We have to have a good framework within which to continue our work. But I know we have a question coming up. We have a question from Susan Clark, who asks, I recently started working for Direct Trust, sharing these comments in case it is anything you would like to share with your audience. There are comments to FTC on the breach notification rule, and also comments submitted to the Senate Help Committee, RFI. Thank you, Susan. That's very helpful. Janice, you have some questions you'd like to ask too.
Yeah, actually, I was actually going to talk about the recent FTC proposed rule updates for the data health breach notifications. And one of the things that is in that proposal is a real expansion of the definition of what is protected health data and when that rule applies. And it includes a lot of non-traditional health information under certain circumstances, potentially like things like your grocery purchases or calendar appointments when they're used in conjunction with other data. What do you think of that approach and how enforceable it is?
So I understand what the FTC is doing, and I understand why they're doing it. I think that there's a strong argument that they are going beyond their statutory authority. So a little bit of history here. 2009, the HITECH Act included two requirements for two breach notification rules. One was for a HIPAA breach notification rule, which we now all know and love. And the other was for the FTC to create a breach notification rule for personal health records. Now, rewind to 2009. What is a personal health record? At the time, leading examples were things like Google had Google Health and Microsoft had Microsoft Health Vault. And these were concepts of, essentially filing, electronic filing cabinets for your medical records. The idea of, you go to your doctor, you get papers, they end up in a filing cabinet in your basement, and they don't do you much good. And you're not readily able to share them with others, that sort of thing. Can we have an electronic version of that? So that, I believe, is what everyone had in mind back in 2009 when Congress required FTC to create a personal health record data breach rule. Fast forward, Google shortly thereafter gave up on its PHR program. Microsoft, it took maybe a decade longer, but they actually ended Health Vault eventually. PHRs in the original sense never really took off. Maybe they will now, maybe their day is coming, but as a result, there wasn't much PHRs out there, and FTC never enforced their rule. But the FTC's main authority, Section 5 of the FTC Act, which prohibits unfair and deceptive trade practices, doesn't provide for civil monetary penalties. And so it's a very powerful statute in many respects, but it doesn't give them penalty authority versus this rule, which was collecting dust because PHRs never really took off. gave them the sort of penalty structure that they really wanted. So they started getting pressure, like Congress started saying, how come you're not using your breach rule? And instead of saying, because there's not really PHRs out there, so if you want to Congress revise the definition, go ahead, they essentially changed the definition of PHR to apply to every health and wellness app under the sun. And I think, I'm not going to get into the weeds as to why I think it arguably violates the statute, what they did, but I certainly, at the high level, their new definition of PHR is nothing like what was, I think, originally intended by Congress back in 2009. So I understand why they're doing it. And who is going to stand up and say, we're going to challenge the FTC on this? Maybe someone will at some point, but no one is kind of proactively leading the charge to say, oh, your health breach notification rule is a violation of the statute and needs to be overturned. So, I think until we get a challenge like that, this is kind of the law of the land. But at some point, someone may push back and say, and challenge it in court. And I think they've have a decent argument.
So if not the FTC on that, then who? Or are you suggesting that at the current time there's no one with the authority to protect apps that don't fall under HIPAA?
Well, the FTC does have the authority, just not necessarily in the health data breach rule. So, we've seen numerous, FTC cases brought against health apps, consumer health apps that don't rely on the health data breach rule, that instead, put in place a 20-year consent order with the health app developer and potentially require them to destroy data that they collected. So the FTC may really like to have the health data breach rule as an additional arrow in its quiver, but if you remove that arrow, they're not defenseless. They do still have their main arrow in their quiver. And then we're seeing states stepping up. Washington, Nevada, Connecticut, and probably other states to follow are looking to regulate these consumer health apps more. So, it's not a complete vacuum, even if you don't apply the health data breach rule to these consumer apps.
So that's interesting that you're relying so much on the states. We absolutely approve of states putting in stricter rules, but one of the pushbacks that the American Hospital Association recently provided to the Senate Health Committee on health data and health privacy was that they felt like it was problematic to have states be allowed to be more strict than the federal government. So can you speak a little bit about
I don't
that?
disagree. It's not that I'm relying on the states. It's just that the states are starting to step up. I would love to see Congress, create a comprehensive framework for privacy and security of consumer health apps and have kind of one robust, good standard. I don't think HIPAA is the right answer. HIPAA was not designed for consumer health apps. But, at this point, we don't even have a speaker in the House. I'm not going, I think health information privacy is one of the most bipartisan issues Congress has, but it's still completely dysfunctional. And, relying on them to put together a robust framework, maybe they give FTC more authority. I don't think the current health data breach rule, I don't think the statutory authority is there, but Congress could certainly revise that and give FTC more authority. But there are many in Congress who do not want to give FTC more authority, who think that FTC is a runaway train. So that's a controversial issue.
Let's look at a variation of this question when it comes to complexity and organizational size and the like. Much of what we see when it comes to internet connected devices, the distribution of care across multiple sites, patients wanting access to their data in personal apps is, sort of augurs for a future where organizations are more distributed. They're smaller. They put more of this information in the patient's hands in devices that are sufficiently secure, but given the patient's choice, the data belong to patients, and healthcare organizations increasingly sort of de-risk or reduce their exposure to risk by not being the holders of all these data and the arbiters of all these technology relationships. Are you seeing in your practice, Adam, people or organizations looking at entirely different ways of looking at their information strategies and looking at ways that they can divest themselves of the tremendous burden that they found themselves bearing when it comes to this? Do you see any novel approaches or any discussion among your clients about ways in which they can reduce their risk by divesting themselves of the ownership of so much of these data and placing them more closely, for example, with patients and consumers?
I've heard it in theory. I'm not seeing it in practice. So, for example, under, I think, the Obama administration, there was kind of a moonshot idea of, a precision health initiative where consumers, million plus consumers share their information with NIH to allow for great inroads in precision medicine. And so, there was this idea potentially of, instead of having, collecting the information from the healthcare providers directly, and either them having to get the consent of the patients or having a basis to do so without their consent, let's have the patients be the stewards of their data and have the disclosures go through them. And it's a really great theory. And interoperability is making baby steps towards that being a possibility, but we are so far away from that. And then, even if we do get to the point where every consumer can access all their medical records as easily as they could potentially access their financial records from their financial institutions, and have that on their phone, and then they become the steward and they decide whether to share it, rather than it falling on the hospitals to be the ones that are the data stewards and sharing the information. Even if we had the technology for that, there's still the big question of, is it a viable model in practice? Will patients actually be sharing their information for research more and things like that? And I think that's really completely untested. So, I've certainly heard the concept of, patients should be the stewards of their data and the data should flow through them rather than around them. But I haven't seen much in practice on that front. And even if the technology is there, I don't know if patients are going to be taking on that responsibility en masse.
I think that's a very good point. Now, we're nearing the top of the hour, Adam. I want to thank you for your time. I don't know if you'll be able to stay with us for another 30 minutes, but you are certainly welcome to. But I wanted to thank you for, terrific. I wanted to thank you for your participation. For those in the audience who cannot stay with us, don't forget that we have a meeting coming up, as Bill Young described, with the uses of AI with our friend and colleague, John Halamka, the president of the Mayo Clinic platform, and Stephen Konya from the Office of the National Coordinator. This will be an excellent session. This is Thursday, November 9th at 9 a.m. We look forward to seeing you there. And if you have to leave, don't forget to complete the survey that comes up on your screen at the end of this session. So why don't we go back to our discussion. And Janice, I know there were several questions that came across the transom. Do you have other questions you'd like to present to Adam?
Well, let me actually start with this. I know that everyone talks about HIPAA and the FTC as providing oversight to some extent or another on all of this, but there's actually a hole in that the FTC doesn't have any authority over nonprofit organizations. Can you address that and what you think might be necessary, or if you think it's necessary to address that hole, and if so, how you think it could be done?
It's a very good point. Nonprofits, oddly enough, are one of the biggest holes in privacy and security. So, we see at this point, 13 states, I think, have passed general privacy laws. And of those, I think 10 exclude nonprofits. The FTC, you're right, under Section 5 does not have authority over nonprofits. They do with respect to their health breach notification rule, but almost no vendors of personal health records are going to be nonprofits. So it's kind of almost moot that that rule applies to nonprofits. In practice, I don't know how much of a problem it is with respect to health information, because I feel like, what are the nonprofits who are getting health information and are not subject to HIPAA? If you're talking about, in healthcare, most of the nonprofits, to my view, are oftentimes going to be hospital systems, health systems, and certainly many health plans are actually nonprofits. I think the Blues are nonprofits, if I remember correctly.
That's correct. Yep.
Yeah, and in those cases, they're covered by HIPAA. With respect to the Wild West of consumer apps, there's not many of those that are going to be nonprofits. So I don't see there being a big hole there. I mean, yeah, there are nonprofits that run disease registries, for example, that may not be subject to HIPAA, and may not be subject to essentially any law governing them. Now, frankly, if a nonprofit rather than a public health authority is receiving PHI, it's either a limited data set under HIPAA, in which case not a big concern, it's not readily identifiable. Or, if you want to disclose fully identifiable PHI to a nonprofit disease registry, it's usually based on a business associate agreement, and they will have a BAA in place, and so they'll be subject to HIPAA. So but I'm open to being proven incorrect, but I have not seen that many cases of nonprofits who are getting health data to a significant degree, but are not going to be subject to HIPAA. But I would love to hear examples otherwise, because I may be missing that a bit. So I think nonprofits, the bigger issue is non-health data. That if a nonprofit has information about donors and things like that, that may be completely unregulated. The good news is most nonprofits who have that kind of data, reputation is of paramount importance to them, and so that's a big driver for them making sure to have appropriate privacy and security in place.
Great. So
Susan Clark, you've raised your hand. Let me just ask Susan.
Oh, okay.
Clark
Sorry, I missed that the hand was raised. Go for that.
That's all right. We'll get back to you, Janice, but Susan, go ahead.
Yes, you can hear me okay, right?
Yes.
Okay, good. I just wanted to tag on to that, because when the words nonprofit came up, my brain immediately went to more of the community-based organizations, home community-based services that are coming more and more into the fold for SDOH, and just wonder if there's any difference in thought when you start thinking of a community information exchange and how that's going to intersect with a lot of our health data.
That is a really good example. I'm glad you brought that one. I mean, we have guidance that, for example, says you can disclose protected health information for treatment purposes to, for example, a community-based organization focused on finding housing, appropriate housing for individuals. That part of discharging an individual is making sure that they have appropriate housing. So there's guidance out there that says that. Now, what information can you disclose to them? That's going to be subject to minimum necessary when it's going to a non-healthcare provider. So there are limits on what information, protected health information you should be disclosing, but you're completely right to raise them as an example where they may not have very good privacy and security in place as a recipient of that data. I don't know that there's, a good answer there. I don't think there's an appetite to put them under an onerous regulatory program where, they're going to have to put a ton of their resources into security compliance and potentially get, not be able to operate. But we do, of course, want them to have, good privacy and security in place. I certainly see contracts that can put in place to, at least on the privacy side, make sure that there's good privacy. And then, minimum necessary, maybe they're not getting the most sensitive data that makes them, they don't necessarily need a social security number to do what they're doing. So, look at whether you can minimize what information is going over to them, with the understanding that they're not going to have top-notch security in most cases.
Great.
Janice, you had a question. We'll
Yeah,
get back
I have
to
some,
yours.
there's still some audience stuff to follow up on. You talked about this a bit earlier, but obviously there are required regulations around interoperability and also around information blocking, which require people to share information, but that doesn't stop the reluctance to do so in certain cases because there's concern about who's liable when there are breaches or issues around information that was shared. Can you delve into some of the issues and concerns around that and how you overcome them beyond just saying you are required to do it, so do it?
We have this history of these really mixed messages from the government. So, 1996, we want to have people doing a lot more administrative transactions online rather than hard copy. So we're going to encourage people to do that with the transactions rule, but we're also going to add the privacy and security rules that, make it, create penalties for lack of privacy and security, and will scare people. And then 2009, okay, we want to move everyone towards digital records. We want to encourage that, but we're also increasing by tenfold or so the penalties that are available for violations of privacy and security. So we've had this history, and now we have the government pushing for greater sharing of information more than ever before, but we're also very serious about privacy and security enforcement, and we're going to really look to enforce a lot. And so there's always been this constant mixed message. I think, the reality is, dating back to the privacy rule, there's been what I'd call paternalism in medicine with respect to patients' right of access. Like, oh, patients can't handle getting access to their medical information. And the government, has more or less said, nope, you don't get to decide that, other than fairly limited exceptions, like if you think it's going to cause physical harm. 20 years later, we still have those fights going on. We still have healthcare providers not wanting to provide patients with access to their information because of a feeling that they can't handle it. And now information blocking is just the next extension of that. We have the government saying, okay, you need to change culture. You need to be sharing information a lot more than you do, whether or not you necessarily think it's in the best interest of the patient. You, on the most part, need to be sharing this information. And the government's pushing for a cultural change, and it's going to take decades for us to get there. And we don't have an enforcement mechanism yet with respect to healthcare providers and the enforcement and the information blocking rule. We're expecting a proposed
Imminently.
rule. Yeah, we're expecting a proposed rule. It was set, the regulatory agenda said September, but I don't think, last I checked a few weeks ago, it hasn't gone to the OMB yet. So we're still a few months away from a proposed rule. But I think it's going to take years of enforcement, again, with respect to healthcare providers, to really start to change the culture further with respect to, this idea of, sharing information being the default, not the exception.
All right, great. And one more thing from the audience. Are there any special, we talked a little bit about community service organizations in your last response, but are there any special considerations for other smaller organizations or organizations that are more prone to serve specific communities, for instance, fully qualified health centers or some of the community providers where they may still fall under HIPAA, but they may have less resources or things like that?
Well, very qualified health centers are kind of the classic example of why I think, the security rule flexibility is so imperative. I mean, they, as much as we might want every healthcare provider to go out there and get, fully implement NIST 800-53 or high trust, or, pick your framework. Some of these just don't have the resources to do that. And, that's where I think, the government should continue to focus on how can they make it easier. And how can, I thought there was a government report a few years ago that kind of encouraged cloud computing in certain respects. It's not the boogeyman that you need to be scared of, but rather, for a small healthcare provider, a cloud provider may be able to put in place technical and physical safeguards that would not be readily available to a smaller healthcare provider. And so I liked the fact that the government in that report, this was based on some 2015 legislation, I forget when the report came out, was encouraging, was giving practical advice to smaller healthcare providers of what they can do to improve their security. I'd like to see a lot more of that, a lot more understanding that they're not going to be able to do this on their own. What tools can we give them or encourage them to use to help? Another example is the HHS Security Risk Assessment Tool, the SRA. In my view, it is not a good risk analysis tool for a medium or large healthcare provider, and it was never designed to be one. But if it's between, it's designed for smaller healthcare providers, and if it's between that and not doing any risk analysis, that is a much better thing to be doing. So, tools like that, I think, are very helpful in the space.
We have, Janice,
I'm sorry,
you
go
have
ahead.
some other questions. I was just going to say you had some additional questions you wanted to ask Adam as well. So
Yeah,
let's
one
go with
question
those.
I had, since you're really focused on the regulatory and legal side, it seems like more and more different agencies are looking at health data, not just the traditional HHS agencies and FTC. Do you have any thoughts or suggestions on specific agencies that you have your eye on, or that we should pay attention to what they're looking to do in this area, or new upcoming laws that are in discussion that you think would have a big effect that might change or have some material effect on the way that we do stuff around data security and data privacy?
Yeah, my advice is the same as I think, 10 years ago. If you're in California, can you move? And I love California, but, what people, what was a little secret for, that was not well known was the California Department of Public Health, for years, not as much lately, but for years, was arguably the most active enforcer with respect to health information privacy. They did 100 enforcement actions long before the Office for Civil Rights hit that mark. So now we also have the California AG. They with respect to non-healthcare privacy is going to be a lot more active, and we've got a new regulatory agency there. With respect to health information, I would say the AGs, the attorneys general, are the ones to watch. In the past, they have not been big enforcers of HIPAA. There's, a few states like Massachusetts, New York, New Jersey that have done a few HIPAA enforcement actions, but most attorneys general have not brought any HIPAA actions on their own. There's been a few multi-state actions where 40 plus states jumped, worked together. But there's only been, a few of those. But as we see kind of Washington, My Health, My Data Act, and other states following suit, we may see essentially more state AGs getting involved in the future. So I think they're going to be ones to watch as these new state laws, but not necessarily, I think they'll be looking at the consumer health apps a lot more than necessarily, suddenly starting to apply HIPAA. Because, these new consumer health, these new health app laws are really, not meant to cover HIPAA. So if you're a hospital, they're not going to cover your PHI. That's still going to fall to HIPAA, and I don't know that the AGs are going to, step up their HIPAA enforcement that much. So I think we'll see a lot more enforcement actions by AGs, but not necessarily in the HIPAA covered entity and business associate space.
What about on the new regulatory front, like, OMB, or like there's all kinds of agencies that have been putting out RFIs and proposed rules. There's stuff from different aspects of the White House and not just HHS. Are there certain areas there you have your eye on?
Not really. I mean, there's definitely interest in, I think there's a lot of interest in, we saw this with the Senate Help Committee and what you just mentioned in, regulating this Wild West of consumer health apps. But the OMB doesn't have regulatory authority. They're more of a think tank in this respect. And they certainly have authority with respect to federal agencies, but I don't see that the federal agencies are kind of the issue here. So, I think it's really going to fall to either Congress to fill the gaps. And I just, I think they can agree in principle that health information privacy and security is a good thing, but I don't think they have their act together to pass comprehensive legislation. Or, in the absence of that, I think we're going to continue to see states, because, states are followers. I mean, California passed a data breach law, and all the states started following. And then California passed a consumer general privacy law. All the states started following. Washington was the new leader with respect to a consumer health law, and within a year or two states have followed. I expect to see those trends play out. And, the tech companies will push for, federal preemption, but I don't, there hasn't been enough of an appetite at the federal level to preempt these state laws, and I don't know that there will be.
Well, thank
We have
you.
time for one more question, Janice. I think you have one more that you want to ask.
Yeah. So,
Madam?
if you could, so we've been talking a lot about what is or what you think is possible or what you think is what we know is in the works. But if you had power over the world and you could set the rules and have people put in place the security and privacy rules that you think make sense, what are the things that you would like to see happen, and what controls do you think should be put in place in the upcoming few years if you were able to control that?
I think a federal comprehensive privacy framework makes a lot of sense rather than conflicting state laws. I think, it should cover privacy generally, but then have special provisions for certain more sensitive categories of information, like health information. So, I don't think that having a general privacy law and then having a consumer health privacy law as a separate law makes sense. I would like to see them more integrated, I guess, similar to a European model of, GDPR, encompasses health information, but has potentially higher expectations for health information and other sensitive, particularly sensitive information. I think, Congress, with respect to HIPAA, said, okay, we are going to grant HHS authority to create transaction standards. We, Congress, will give ourselves 3 years to create comprehensive privacy standards. And if we don't, then we kick the can over to HHS to do so. I don't see, I don't think Congress should even kid itself. I don't see Congress having the ability to create comprehensive privacy and security framework. I think that they really should set high level, leave it to to appropriate regulatory bodies to create the more detailed framework. And then, similar to what I said earlier, I'd love for the regulators to then look to private, industries or control frameworks on the security side to fill in further details. So I'd love to see kind of a, if you're, a three-tiered system of, legislation that, creates the appropriate authority, regulations that really implement a lot more of that, but then, control frameworks that can be changed a lot more quickly that kind of get incorporated by reference into those regulations. That's, I guess, if I was back at, if I was a congressperson or back at HHS or another agency, that's what I'd love to see.
Great.
We'd love to see that too. Janice, thank you for those questions. I think those were very helpful. Adam, thank you for your responses.
Well, thank you for having me.
Oh, it's our pleasure. Are there any final thoughts or words you'd like to share with us before we adjourn for the day?
So I guess, the final thoughts would be risk analysis, risk analysis, risk analysis. I mean, I think I am all for control frameworks, but I think having a robust risk analysis program, and not just annual, we bring a contractor in to, do it so that we're checking, check the have a check mark next to that, but rather, a day-to-day, we're always evaluating new risks, based on newest headlines or security incidents and things like that. To me, that is the, from a compliance standpoint, that's going to be one of your strongest things for security. And interoperability just makes it that much more challenging to maintain that risk analysis. But, I think your risk analysis should be, closely embedded with all these new interoperability efforts.
Well, thank you very much. This has been a terrific discussion. Adam Green, Davis, Wright, Tremaine, it's always a pleasure to follow you and to talk with you. And we are grateful to have you join our executive forum today. I want to thank you again for joining us. I want to thank our audience members for participating. And I want to recommend that folks complete that final survey when you leave. With that said, you see that we have sessions coming up. We encourage your participation in MHDC events. And we thank you for joining us today. And with that, we're adjourned. Thank you, everybody.